feel me?
Shake it up.
Yeah, feel me? You feel me? No cash on me. Swipe for a million. Yeah, feel me?
It is my duty as well as a pleasure to always bring to my subscribers' attention the incompetency, the biasness, as well as the corruption of so-called attorneys that speak to the media concerning the Brain Kolberger case. This goes for DNA experts, FBI experts, investigators as well. Now, I'm finna prove to you in this video and expose the DNA experts, the court system, all the way up to the appeals court, to the Supreme Court. So, let's get into it. This article was published July the 25th, 2023 by Fox News 35. Now, they spoke with an attorney by the name of John Henry Brown, an attorney who represented a serial killer by the name of Ted Bundy. Here is what he said about Brain Kolberger's alibi defense. I'm going to get to the pertinent part. Brown said the filing is just providing notice that the defense might rely on an alibi without the defendant testifying. My guess is that the cell phone data may try and put the defendant in a place not close to the murder scene, he said. Now, here is the problem. He said, an alibi is an affirmative defense, so notice to the state is required. Let me say this here unequivocally and without any reservation. This attorney is incompetent as well as biased. We have 50 states in the United States, and in criminal law, an alibi is not an affirmative defense. You can't get any lawyer that's worth their salt to put in a sworn affidavit that an alibi defense is an affirmative defense. Any student of the law know that this is not possible. And here is why. An affirmative defense placed the burden on the person asserting it to prove it. Let me give you an example. Stand your ground law. That's an affirmative defense. Self-defense is affirmative defense. If you're in a civil trial and somebody hit your car, and then you say, hey, I'm not responsible for the accident, you are. You must do more than state that. You must state facts that, if proven, would defeat the claim. Now, as you can see, Fox quoted him saying an alibi is an affirmative defense. No. Now let's get to the DNA. I just want my subscribers to know you must not accept what is being said by attorneys in the media because they are called attorneys. A lot of these attorneys are actually incompetent. Let's move on. By the way, an alibi defense is based on a preponderance of the evidence. Okay? Now, meaning, Mr. Kolberger does not have to prove his alibi. The prosecutor must disprove it. Once again, my name is Speak Van Holden 247, etc. I'm smashing all lawyers with misinformation. Let's get to this DNA, man.
Genetic genealogy is simply a tip. It's a lead generator. It's a highly scientific tip, but it's still just a tip. So we can point law enforcement in the right direction with this technique, but they still have to perform their full investigation.
Genetic genealogy and how it was used in the Idaho 4 murder investigation is becoming a major issue in the case against Brain Kolberger. And now, court documents reveal Kolberger's defense may claim DNA on a knife sheath was planted. Thanks for joining us here on Law and Crime. I'm Anjanette Levy. We reported a few weeks ago that prosecutors asked the court to issue a protective order on the genetic genealogy information developed by the FBI using a DNA profile obtained from the snap of the knife sheath found on Maddie Mogen's bed. Kolberger faces the possibility of the death penalty if convicted of the murders of Mogen, Haley Gonsalves, Xana Kernodle, and Ethan Chapin last November. The defense wants to show how the FBI used DNA to create family trees that led them to Kolberger and his father. It's clear from reading court documents and from covering the case that law enforcement had very little to go on until genetic genealogy came into play. Kolberger's defense attorneys wrote in their objection that they want to see how many other potential suspects were overlooked, and they even suggested that Kolberger's DNA could have been planted. They wrote, "What the state's argument asks this court and Mr. Kolberger to assume is that the DNA on the sheath was placed there by Mr. Kolberger and not someone else during an investigation that spans hundreds of members of law enforcement and apparently at least one lab the state refuses to name." Prosecutors have now responded to the defense's objection, writing, "Presumably then, defendant was attempting to show how the investigative genetic genealogy information is material to the preparation of his defense when he asserted that someone other than the defendant may have placed his DNA on the K-bar knife sheath. But the state is at a loss as to how that theory supports a claim that the IgG information is material to the preparation of his defense. In other cases, prosecutors haven't been forced to turn over the genetic genealogy information. I spoke with C.C. Moore, an expert in the field, about this earlier this year.
The precedent that we've seen set is that this does not need to and should not be presented in court in front of a jury. So far, it's really been discussed in pretrial hearings, grand jury trial hearings, if at all. I've been on hold for dozens of cases to be an expert witness, and I've been canceled in every single one because of the precedent that we're seeing set, because of the rulings the judges are making. Oftentimes, when the defense tries to object to the genetic genealogy, and they lose, which they have in every case so far, they end up doing a plea deal.
Kolberger's trial is currently set for October. Meanwhile, I spoke with Kristen Slaper, an expert in DNA analysis, who managed DNA analysis for years for Ohio's Bureau of Criminal Investigation's Crime Lab. I asked her about the possible claim that DNA was planted and the arguments over genetic genealogy.
What's important to remember is that, first of all, DNA on its own doesn't mean anything until you have a standard to compare. So what I mean by that is you could run DNA tests all day long, get profiles from someone or multiple people, and you don't really know what it means until you either put it into the CODIS database or you compare it to a standard that's submitted. So in a situation like this, where I hear that the claim is DNA is planted, I think it's important to remember that Brain Kolberger was not known. Nobody knew who did this. And I think that's important because in order for something to be planted, it has to be a pretty, it's got to be pretty planned out to plant someone's DNA. You have to have their DNA, first of all. You have to have an item that their DNA is on and know that only their DNA would be found on it in order for a result to be produced the way that it was, for it to be one person on this knife sheath, for it to be enough DNA that you could generate a profile from this, that you could put it into CODIS, that you could then go on to do genealogy. You have to have a decent amount of DNA for that. And so it has to be really carefully planned, I think, if you're going to plant someone's DNA. And then, like I said, not knowing who the person is when the DNA lab runs the test, the DNA lab is only generating what's there and what they have. And we always had a saying in the lab that you either get the right answer or you get no answer, because you're working the evidence that gets submitted by the law enforcement agency. And sometimes you would get a profile and other times you wouldn't. So in my mind, to plant someone's DNA, I think it takes an awful lot of work. And I think it's a little bit too coincidental with all the other facts of the case. Not knowing the outcome, not knowing who did it, that's just my opinion.
Idaho Moscow PD and the prosecutor for the state of Idaho, Moscow, don't want you nor potential jurors to understand the DNA evidence. They don't want you to understand the science nor the methodology behind what they call the DNA evidence that places Brain Kolberger at the scene of the quadruple murders that happened in Idaho, Moscow. DNA experts, just like any expert in America, they are like the common whore on the street selling her body. For the right amount of money, that whore on the street would get in bed with the trick or the John and perform any sexual deviant act that John may desire. Likewise, for the right amount of money, these DNA experts will get in bed with the prosecutor and perform any sexual criminal act that they desire in a form of fabricated, falsified testimony. Now that is really kinky. So let's get into it. As far as back as 2009, scientists in Israel and other places have known and proved that you can fabricate, plant, manufacture DNA. For purpose of this video, if we are to really understand the prosecuted case against Brain Kolberger, we must educate ourselves. We must arm ourselves with knowledge that will allow us to decipher what's really going on. Now, let me be clear. I'm not saying Brain Kolberger is guilty nor not guilty. I am saying that Ann Taylor is putting on a magnificent defense, and I really didn't know that this woman was a gangster. She making gangster moves, and she got a posse with her. Let's get into it. John Pollock wrote this. It was featured in the New York Times back in August 17, 2009. Let's get some education. Scientists in Israel have demonstrated that it's possible to fabricate DNA evidence, undermining the credibility of what has been considered the gold standard of proof in criminal trials. The scientists fabricated blood and saliva samples containing DNA from a person other than the donor of the blood and saliva. They also showed that if they had access to a DNA profile in a database, they could construct a sample of DNA to match that profile without obtaining any tissue from that person. Hold up. You remember what Kristen Slater said? She tried to make us believe, she wants the public, the people, the jurors, potential jurors to believe that Moscow PD didn't know it was Brain Kolberger. They didn't have a sample of his tissue. Well, I beg to defer, because guess what? Moscow PD has stated that they watched him clean his car. So what prevented them from going there, picking up what they claim he cleaned up, taking it to a lab, and doing him dirty? You know, doing what they do. You're about to find out how they do this here. So, they also claim that Moscow PD went to Brain Kolberger's father and mother's home and went through the trash can and got DNA. Well, I'm about to show you the very thing that they claim that they did can pretty much hurt their case if Ann Taylor played right. Let's get on with it. Now, I can't remember where I stopped. Oh, yes, I can. Let's get back there. You can just engineer a crime scene, said Dan Frumkin, lead author of the paper which has been published online by the Journal of Forensic Science International, Genetics. Any biological undergraduate could perform this. Now, you remember Christian Slater said it's hard. It's hard and hard. She proclaimed that in 2023 between June and July. This was proclaimed back in 2009, as far back as 2009. Dr. Frumkin is a founder of Nuclei, a company based in Tel Aviv that has developed a test to distinguish real DNA samples from fake ones that in hopes to sell to forensic laboratories. The planting of fabricated DNA evidence at a crime scene is only one implication of the findings. A potential invasion of privacy is another. A potential invasion of personal privacy is another. Using some of the same technique, it may be possible to scavenge anyone's DNA from a discarded drinking cup or cigarette butt and turn it into a saliva sample that could be submitted to a genetic testing company that measures ancestry of the risk of getting various diseases. Celebrities might have to fear genetic forensics, said Gal H. Javid of the Genetics and Public Policy Center at Johns Hopkins University. Tana Samoli Selly, hope I'm pronouncing her name correctly, science advisor to the American Civil Liberties Union, said the findings were worrisome, and rightfully so. The DNA is a lot easier to plant at a crime scene than fingerprints, she said. We're creating a criminal justice system that is increasingly relying on this technology. John M. Butler, leader of the Human Identity Test Project at the National Institute of Standards and Technology, said he was impressed at how well they were able to fabricate the fake DNA profiles. However, he said, I think your average criminal wouldn't be able to do something like that. Now, let's pause right there. Remember, if they got Brain Kolberger's father DNA, and they done admitted this, they done already admitted that a plausible, realistic, factual, and scientific argument can be argued. It can be argued by Ann Taylor that it was planted. And this is what Ann Taylor argued, that it was planted. Now, when you look at this here, remember, they say they followed this man, kept watching him cleaning his car. So if you're a cop, an investigator, and you watching him clean your car, of course you're going to try to go over there and get some DNA. And it's a possibility, in my opinion, that they planted the DNA as well. Because you claim that you was watching him clean his car on various occasions. So why wouldn't you go over there and try to scavenge DNA? I believe you did. And this is why it only appeared on a button sheet. Let's get to it. The scientists fabricated DNA samples two ways. One required a real, if tiny, DNA sample, perhaps from a strand of hair or a drinking cup. They amplified the tiny sample into a large quantity of DNA using a standard technique called whole genome amplification. Of course, a drinking cup or piece of hair might itself be left at a crime scene to frame somewhere, but blood or saliva may be more believable. Now, let me pause right there. See, blood or saliva is more believable. Basically, what they telling you, skin cells and anything else at a scene of a crime, it really not believable. This was stated far back as 2009. Remember, C.C. Moore even admitted that blood and saliva is more believable. So now we got these skin cells that are suspect. I'll let you arrive at your own conclusion. Let me keep going. The authors of the paper took blood from a woman and centrifuged it to remove the white cells which contained DNA. To the remaining red cells, they added DNA that had been amplified from a man's hair. I believe this is what Moscow PD did, and this is why they don't want to reveal the lab. This is just my belief. Since we are arming ourselves with facts, I'm about to help a lot of people look at this case in a more scrutinized way. Okay, let's get into it. Since red blood cells do not contain DNA, all the genetic material in the blood samples were from the man. The author sent it to a leading American forensic lab, which analyzed it as if it were a normal sample of a man's blood. Keep that in mind. The other technique relied on the DNA profile stored in law enforcement databases as a series of numbers and letters corresponding to variants at 13 spots in a person's genome. From a pooled sample of many people's DNA, the scientists cloned tiny DNA snippets representing a common variant at each spot, creating a library of snippets to prepare a sample matching any profile. Holy jelly sandwiches, Batman. They just mixed the proper snippets together. Sound like a gumbo to me. They said that a library of 425 different DNA snippets would be enough to cover every conceivable profile. And that goes for Brain Kolberger's profile. Things beginning to look a little bit great for Brain Kolberger. So as you can see, Ann Taylor got hands. She probably can beat Roy Jones. Let's go on with it. Nuclear tests to tell if a sample has been fabricated relies on the fact that a amplified DNA, which would be used in either deception, is not methylated, meaning contaminated, meaning it lacks certain molecules that are attached to the DNA at specific points, usually to inactive genes. Now, based on what you have read, based on what you have seen, do you see now why the prosecution case is a problem? Let me put it like this. Let me just back up. This is why I say Dylan Mortensen is a false fabricated witness. She could not have seen Brain Kolberger. This is the description they give him, okay? This is why I tell you that they're trying to use her alleged seeing a masked man that resembled Kolberger to make a strong case. But as you can see, when you look at what we just explored, how many of y'all really put confidence in a Moscow PD, seeing that they don't want to reveal the FBI notes or how y'all came to this here? Hey, it gets better. So we feel about to transition to another part of this DNA. Come on, ride with me. This article was wrote by Marina Medvine, a former contributor to Forbes magazine. She also writes about constitutional law, criminal law, and privacy law. She wrote this article back on September 20th, 2018. Let's get into it. I'm only going to read and point out the pertinent parts for purpose of making my point in this video. Modern technologies can now detect and analyze DNA from samples comprised of only 16 cells. But due to the touch transfer properties of DNA, determining how those cells reach the surface on which they were found is impossible. Tiny amounts of touch transfer DNA have placed people at locations they have never visited and implicated people for crimes they did not commit. When we consider the quadruple murders in Idaho, Moscow, in which Brain Kolberger is charged with, we understand now that the prosecution case of the felony burglary as well as the quadruple murders cannot be dependent only on the so-called touch transfer DNA found on the button sheet of the knife. So, as you know, they concocted a witness, Dylan Mortensen, better known as DM. All of a sudden, she alleged that she saw a masked man when she opened the door in Frozen shop. Consequently, her description was designed to make it appear that she saw Brain Kolberger. Let's continue. Forensic technology detecting and analyzing DNA evidence have been at the forefront of criminal investigation. Scientists have told us that the perpetrator of a crime will leave traces of his DNA at the crime scene. And if found in even small amounts, the evidence can be used to identify the perpetrator. Finding a suspect DNA at a crime scene on a victim or on a piece of evidence is consistently used by law enforcement to place a suspect at the scene of a crime with the victim or in contact with the relevant piece of evidence. In this case, it is the knife sheet. Prosecutors have been representing DNA evidence as superior to all other types of identification evidence. However, research conducted at the University of Indianapolis shows that the detection of DNA does not actually indicate presence or contact. In fact, it may not narrow the scope of the investigation at all. Now, we are aware that 2 other persons' DNA was found at the scene of the crime in the area where the knife sheet was. Ironically, Moscow PD did not think to work that DNA, or perhaps they did work the DNA and it reveals something they don't want nobody to know. Let's go on. I'm going to skip down to the pertinent part. You are welcome to read, or you are welcome. You are advised to read this article in detail. I am just going through the pertinent parts. Okay. We're going to start right here with DNA is curiously. DNA curiously appeared on things that they have never touched. Let's go on down here. 4 Indianapolis scientists recently questioned the reliability of the modern-day high-sensitive forensic lab technology used by law enforcement to identify suspects via DNA. They explained that even though current technologies utilized by forensic laboratories are now reading DNA profiles from low template and low-quality samples, they have not been systematically investigated. The scientists published their findings in 2016 in their Journal of Forensic Science under the heading, "Could secondary DNA transfer falsely place someone at the scene of a crime?" Their answer was unequivocal yes. Touch transfer DNA could falsely link someone to a crime, and forensic scientists relying on modern high-sensitive equipment could falsely conclude that DNA left on an object is a result of direct touch. Their findings reveal that it is impossible for scientists to determine whether the tiny bits of DNA came into contact with the evidence from a direct source or by a secondary source, and that no matter how much they tried to sanitize their experiment, unknown third-party DNA was nonetheless able to make its way into the results, highlighting the plausibility of cross-contamination with touch transfer DNA. So, as you can see, the prosecutor, Bill Thompson, has a real serious problem with the DNA. And they know this because this trial is going to boil down to expert versus expert, who the jury choose to believe. Now, as you can see, simply because the alleged defendant Brain Kolberger DNA is alleged to appear on the knife sheet button doesn't mean he ever touched it or even was at the scene of the crime. This is what Ann Taylor really wanted to find out. Now check this out. The FBI standard for DNA laboratories was last updated in 2011. And to this day, no changes have been made to reflect the 2016 Indianapolis findings. Stop right there. You remember that the FBI worked up the DNA for Brain Kolberger through the genealogies of the ancestry stuff on the website. This article was wrote back in 2018. And it was showing, and right now it's letting you know the FBI wasn't even updating their database to recognize this here. So as you can see now, Ann Taylor is doing a very, very professional job in defending Brain Kolberger. I actually see where she's going. Let's get on with it. There are currently no widespread standards in place that are specifically aimed at preventing cross-contamination with touch transfer DNA in the laboratories where various evidentiary objects are examined. This means that when objects that are placed on shared surfaces in a laboratory to be examined or photoed, for example, they are subject to cross-contamination by touch transfer DNA. The same goes for the initial discovery and investigation of evidence when the evidence is first handled by the police. Now remember, it is said that the prosecution is not going to use the touch transfer DNA found at the scene of the crime. Whether they use it or not, the defense still have a right to bring that up. They still have a right to bring it up. And I do believe they are going to bring it up. As a matter of fact, if the police found touch transfer DNA of Brain Kolberger at the scene of the crime, why wouldn't they want to use it? Why would you make known that his DNA was found on there then? And then all of a sudden, you want a gag order? I don't like it. It smells like poo-poo. Let's get on down with it. The presentation of touch transfer DNA as bulletproof to the presentation of touch transfer DNA as bulletproof to a jury is thus even more worrisome. During a criminal trial, lawyers for the government and for the accused are expected to present competing possibilities of how a crime could have occurred and who may have been responsible for the crime. A jury is not confined to the mathematical computation of criminal culpability. Instead, a jury is free to choose among reasonable constructions of the evidence. Overcome with anxiety and fear of making the wrong choice, juries tend to rely on the existence of or the lack of forensic or DNA evidence presented to them at trial. Thus, when the prosecutor presents to a jury touch transfer DNA evidence with the same oomph as large sample DNA evidence, the jurors, under the influence of preset expectations for scientific evidence to prove culpability and the common notion that DNA evidence is inherently trustworthy, feel compelled to convict. The results is touch transfer DNA can readily lead to a conviction of the innocent. Now, like I said, they do not want the jury to understand the science behind what they are calling evidence of DNA that place someone at a scene of the crime or that proves that someone committed the crime. And let's get on to this. Y'all going to find this really interesting. In 2007, Amanda Knox was charged with the murder of her roommate. I really don't like the way they wrote this article. Let me start over. In 2007, Amanda Knox was charged with murder of her roommate based a minuscule scale amount of touch transfer DNA. Knox DNA and the DNA of the victim were found on a kitchen knife that was located in the home of Knox's friend, who was charged as a co-conspirator in the murder. Since the victim was never in the co-conspirator residence, the prosecutor insisted that the only way for the victim DNA could have found its way into that home and onto the knife would have to be through direct contact, the murderer. In 2009, an Italian jury convicted Knox, even though the knife in question did not match the entry wounds on the victim's body. Man. Now, I want y'all to really let that sink in. The knife wound did not match the weapon. It was not until 2015 that Miss Knox was exonerated based on a more precise understanding of how DNA transferred through contact and on concerns with touch transfer DNA cross-contamination. Let's move on to the next story. In 2012, Lucas Anderson was arrested and charged with the murder of a millionaire in California. Traces of his DNA were found on the victim's fingernails. Law enforcement crafted a theory of the case based on the evidence in Anderson's lengthy criminal record. Dangling the death penalty over Anderson's head, Anderson was unable to effectively assist in his own defense. He said, Maybe I did it, he told a public defender, not remembering what happened on the night in question due to significant intoxication. After spending 5 months in jail, Anderson was released when it was uncovered that he was at the hospital when the crime occurred, recovering from intoxication. Now check this out, people. Watch how his DNA found its way there. But how did his DNA get on the victim's fingernails? Anderson was the victim of touch transfer DNA misinformation. 2 paramedics who had treated Anderson for intoxication hours before the millionaire was murdered later responded to the scene of the murder with Anderson's DNA already on them. Contact between the paramedics and the millionaire resulted in the exchange of DNA on their hands, which just happened to include Anderson's DNA from contact that took place hours prior. Now, let that sink into your head. Remember, C.C. Moore said that touch transfer DNA finding its way somewhere else is rare. In 2014, Oklahoma City police officer Daniel Horseclaw was charged with various sexual assault crimes stemming from accusation of women he encountered while on patrol. While the case initially appeared brittle from forever changing victim accounts to evidence contradicting the stories altogether, a speck of DNA from one of the accusers was found on the officer's uniform pants. Unlike a visible sample of identifiable DNA, the DNA found on Horseclaw pants was instead invisible, touch transfer DNA. In fact, his patrol car though produced 4 times as much DNA as the speck on his pants. The evidence also confirms that Officer Horseclaw searched the accused's purse for evidence on behalf of the police department. Before he was swabbed for DNA rummaged through her personal belongings, his hands plausibly coming into contact with a plethora of her DNA. He also used the restroom, touching his pants in the process, consistent with the touch transfer DNA properties. An unaccounted for and unknown male's DNA had also been found on Horseclaw pants, together with the female's DNA. Nevertheless, the prosecutor told the jury that the speck of female DNA evidence was conclusive proof of sexual contact between Horseclaw and the victim, and then, unsupported by his own evidence, claimed that the particular DNA came from the victim's vagina, a scientifically impossible conclusion. The jury found Horseclaw guilty and sentenced him to 263 years in prison. Man, they was trying to hide him. Keep in mind that the prosecutor theory didn't even make sense to the jury, but yet they found him guilty. His appeal is presently pending. Daniel Horseclaw currently sits behind bars and maintains his innocence. These are just 3 examples of yet unknown total amounts of criminal prosecutions based on the government's reliance on touch transfer DNA evidence at trial. At least one of the affected defendants, Daniel Horseclaw, is still in prison. Many others may be charged in the future. On at least one known occasion, the lack of touch transfer DNA has been used by governments to clear suspects. In 2008, the Boulder County District Attorney cleared members of the John Bennett Ramsey family as suspects in the high-profile murder case when investigators did not find any touch transfer DNA from the members of the slain girl's family or on her clothes. The Ramsey case remains the exception rather than the rule. Let's go on to here. Moving forward, law enforcement must reduce reliance on the DNA evidence while investigating a criminal case. It is not a dependable means of understanding the connection between DNA and the crime. For criminal trials, it should become standard practice for judges to sustain defense motions for the exclusion of DNA evidence on the grounds that DNA evidence is confusing and misleading, highly prejudicial, speculative, and inherently unreliable. Otherwise, our courts risk DNA convicting the innocent. People, this is what they've been doing for a very, very long time. And this is why Ann Taylor knows this as well. But Ann Taylor is fighting against the courts as well as every prosecutor who does not want them to know the methodology. Because once you understand the methodology, you will fully understand that this DNA ain't all what it's cracked up to be. Let's keep going. I'm gonna close this section. Oh man, I said I'm gonna keep going, but I'm actually finished with that part, so let's transition.